Under the attorney-client privilege, an attorney may not disclose to third parties any confidential communications between the attorney and his client. In United States v. Ruehle, the Ninth Circuit considered whether the attorney-client privilege applies, even if a client knows the communications will be shared. In 2006, the United States Securities and Exchange Commission investigated Broadcom Corporation for allegedly backdating employee stock options. Several private parties also sued Broadcom, naming Broadcom's chief financial officer, William Ruehle, as a defendant. Broadcom hired the law firm of Irell and Manella to conduct an internal investigation into the company's stock option practices. As part of its investigation, attorneys from the law firm interviewed Ruehle, during which Ruehle made some incriminating statements. During the interview, Ruehle and the attorneys didn't discuss the private lawsuits against Ruehle, and Ruehle didn't seek legal advice in his individual capacity. After the interview, the attorneys advised Ruehle to retain separate counsel to represent him in his individual capacity, which he did. The law firm subsequently disclosed Ruehle's statements to the accounting firm of Ernst and Young, which served as Broadcom's external auditor. The federal government eventually launched a criminal investigation of Ruehle. The government interviewed the attorneys about their previous interview of Ruehle and ultimately indicted him for securities fraud. On the government's motion, the United States District Court for the Central District of California held an evidentiary hearing to determine whether Ruehle's statements to the law firm attorneys were protected by the attorney-client privilege. The attorneys testified that, before speaking to Ruehle, they informed him that they were acting as Broadcom's attorneys and that the attorney-client privilege therefore belonged to Broadcom. Ruehle asserted that he understood that the law firm represented all of the named defendants in the private lawsuits, and therefore that he had a personal attorney-client relationship with the law firm. However, Ruehle also stated that he expected the law firm to disclose the information from its investigation to Broadcom's auditors. The district court found that Ruehle's belief that the law firm attorneys were his personal attorneys was reasonable, and that his incriminating statements were therefore confidential communications covered by the attorney-client privilege. Because Ruehle never gave the attorneys consent to disclose his confidential statements, the district court suppressed Ruehle's statements. The government appealed to the Ninth Circuit,